Welcome, welcome, welcome. Thank you for joining us at this beautiful venue on this lovely morning. My name is Aaron Kinney. I'm the legal director at the Disability Law Center. And on behalf of the Disability Law Center, we welcome you. Thank you. I'll get really close to the mic, which is hard because I'm kind of tall. But so if you don't know who we are Utah's Protection and Advocacy Agency for people with disabilities. We're designated by the governor. And we're empowered by federal statute to enforce and strengthen the laws that protect people with disabilities. So what does that mean? Lately, to me anyway, it feels a lot like we're suing prisons and jails and fighting discrimination and ugly things like deliberate indifference and things like that. But I'm happy to say that we're here on a more positive note today. This conference is entitled Successful Strategies for Integration. And that is a great thing. So if you're here, it means that you are dedicated to that principle just as we are. So specifically, I'm excited today to learn about Medicaid's home and community-based settings rule and how that will work to ensure that individuals with disabilities who are receiving waiver services are able to direct their lives in the most inclusive and integrated way possible. So without further ado, I will turn the time over to my colleague, Laura Henry, who will give some more information and introduce our speakers. So again, thank you for being here.
Thank you, Aaron. Can you all hear me just fine? As you can see, I am not as tall as Aaron, so I do not have that same problem. So thank you all for being here again today, and thank you to Aaron. I'd also like to briefly thank our executive director, Adina Zaradnikova, and the rest of our senior management staff, because without their support for this conference today would certainly not have been possible. We'd also like to thank several of our colleagues and coworkers who have taken the day off out of their own work to come here today to assist us to make sure that things run smoothly, and we realize that that's a sacrifice, and we really appreciate it. So thank you to them, and again, thank you to all of you for being here. Briefly, I want to just mention a few housekeeping items. Obviously, there is a food spread right over here, so if you haven't had an opportunity to get some breakfast, please do that. We've got lots of what we think is really good food, so please enjoy yourselves. There's also 3 sets of restrooms. There's one on the far east side, one set right behind the registration tables, and one also on the far west side over here. So please know that those will be available all day. We also have a quiet room for anyone who might need to take a break sometime during the day. It's located in classroom 103, and it's over here past the breakout session. So you have to keep going a little bit to find it, but there is a sign in case you should need to use that. And there's a beanbag chair and some other great things should you need to utilize that room. So without too much further ado, as Aaron mentioned, my name is Laura Henry, and I supervise the community integration team at the Disability Law Center. As that name would suggest, our team focuses on ensuring that people with disabilities have access to their community in a fully inclusive and integrated way. And so since 2014, when the home and community-based settings rule was rolled out, we've tried to do a lot of work to raise awareness about the rule and to educate consumers and families, stakeholders, providers about what the rule means for them. So as part of our advocacy efforts, we've done a number of different things, and you may have seen us out and about over the last couple of years. We have had several training sessions at our offices in Salt Lake, as well as at other venues across the state. We have hosted webinars, and we've also had the wonderful opportunity to visit many settings, both residential and non-residential. And we've had the opportunity to speak with consumers of home and community-based services, as well as providers, to get a sense of what their experience is with services, and that's been a really fantastic opportunity to us. So if we visited you, thank you so much for your hospitality. In 2016, we released a report that summarized the findings of a survey that we conducted as we went out and visited folks. And the survey and the report was really meant to kind of give a status update of where we felt like the service system was, what was going really well, and then what may need to be addressed in order to be fully compliant with the rule. And so that was released in March of 2016. And since that time, we've continued our efforts by visiting many more providers throughout the state, talking with more consumers as well. And one of the things that we've kind of heard repeatedly as we've been out and about is that there's a great will to assist people with disabilities to be integrated and included, but that there are some barriers in order to make that happen. And so one of the things that we're really hoping to accomplish today with this conference, in addition to raising the profile of the home and community-based settings rule and providing good information, is also to just offer some practical tips and strategies for how we might work through some of the barriers that have kind of come up over and over again. Because whether or not we have the home and community-based settings rule, as Erin mentioned, we think everyone in this room is committed to the right principles of inclusion and integration, because we believe that a person with a disability's life shouldn't look fundamentally different from anyone else's, and that to the degree that it does look different, those differences shouldn't be because someone uses services or because someone needs support. So those are the principles that we're here to celebrate today. We're so thankful that you guys were willing to come. We appreciate, again, all the goodwill in this room. We think we have a great lineup for you today. Starting off very strong, we have Elizabeth Edwards, who is a senior attorney at the National Health Law Program. For those of you who might not be familiar with the National Health Law Program, or NHELP, it's a fantastic organization that works to protect underserved populations, protect their health rights. Elizabeth is a senior attorney there and works on litigation as well as policy and legal education. Prior to joining NHELP, Elizabeth also worked at Disability Rights North Carolina, so you can see she's come a long way to join us this morning, and we're really grateful to have her here. She's certainly dedicated to the principles that I've outlined this morning, and we couldn't be more excited to hear what she has to say. So please join me in welcoming Elizabeth Edwards.
Good morning. Let me get this mic adjusted for me since I'm somewhere between the previous two people. So I am from the National Health Law Program, or NHELP, and I do have a background in working direct services for people with disabilities. Let me get my little remote here going. So as was just explained, NHELP is a national legal organization, and we do work across the U.S. about public health and including services for people with disabilities. And one of the main things I've been working on over the past couple of years is community integration. And that includes this rule and making sure that this rule is properly integrated or implemented in all the different states as we move to make sure it happens. But the important thing about this rule is that it's not really new. There's nothing in it that has not already been decided in the courts about Olmstead cases. It may be new things sort of that we're seeing in a rule form, but most of the things that are in this rule have been established either in previous Department of Justice guidance, or they are been mentioned in case law where people have brought Olmstead cases. So it is kind of an implementation of what has been moving forward regarding Olmstead and the right of people with disabilities to live in the community, work in the community, and be a true integrated part of their own communities. So as we look about implementing this rule, it really is an unprecedented opportunity for states and advocates and providers and everybody involved to look at what do we have? What do we have? What's missing? Let's make sure that all these changes we're going to make are really the changes that are going to move us forward in the right direction and make sure that the state and all the providers and everybody is really meeting the goals of Olmstead and the Americans with Disabilities Act. It is an opportunity to really expand capacity of more integrated settings and also move state systems away from outdated models. And the big key is that it really will help a state comply with their Olmstead obligations and help them sort of avoid perhaps future litigation on Olmstead issues. I wanted to really kind of talk about what is our overarching goal when we talk about home and community-based services. As we mentioned before, we really want to support people with disabilities to have the lives like other people without disabilities. There shouldn't be a difference in somebody's experiences based on whether or not a person gets services. That's in the rule. That's also in previous Department of Justice guidance. We really want to make sure that there's opportunities for true integration. We don't want everything to be scheduled. That's not necessarily supporting a person's choices and what they want to do. And we want to make sure that people with disabilities are integrated in every part of their lives. So I mentioned briefly that this is all sort of part of a larger movement towards community integration and what that really means, and part of the movement to ensure that people with disabilities are achieving their civil rights in terms of integration of the community. We have been moving for years and years and years away from institutions to community-based settings, as I'm sure many of you are aware. Public funding used to only serve people in institutions, and since the 80s, we've had waiver services that we're mostly familiar with in this room. But those waiver services have never really had a definition for what the settings they should be provided in. And only now with our community-based services rule are they really defining where these services should be provided. I really added a few slides on where we are with moving towards community integration and funding. As you can see, LTSS, long-term services and supports, we've been moving away from institutional funding and towards greater community integration. And that will continue as we move forward. I did want to highlight, though, that Utah is somewhere in the middle in terms of whether or not they are providing most of the funding in community-based services versus institutions. They are slightly below the national average. So why do we have this rule? As I said, this rule is really about implementing Olmstead and implementing the Americans with Disabilities Act and the person's right to live in the community. So we have our civil rights laws, the Americans with Disabilities Act, the Section 504 of the Rehabilitation Act, and Section 1557 of the Affordable Care Act. And all of these statutes basically say that a person with a disability has the right to live in the community and not be segregated from the larger community at all. That to live separately, to live in a segregated setting is discrimination. And that's clearly what they say. I did want to add this. A lot of people have never actually seen pictures of the people behind the Olmstead lawsuit. So if you've never seen Lois Curtis and Elaine Wilson, those are those two ladies in that picture, and they're the ones who brought this case that was heard in the U.S. Supreme Court. And when I say Olmstead, which I've said a lot and will continue to say, it is the Supreme Court case that said having people live, play, and work in settings that are not integrated violates their civil rights. And they have the right to live in the community and be integrated in the community. Some people have said, well, Olmstead is just about moving from institutions to community, and it's not. Olmstead in no way is just about institutional versus community living. It is about whether or not the person is truly integrated into their community. And there's other sort of cases about this, which we'll go over, but there's no limiting language in that, in the Olmstead, nor in the ADA. So when people say, well, oh, you really only have the right to live either in the institution or in some form of community, that's not true. You have the right to be fully integrated into the community in the least restrictive setting appropriate to your needs. And that is what the Department of Justice, U.S. Department of Justice, that handles civil rights issues and disability issues, has interpreted Olmstead and the ADA and put forth guidance. You'll see, if you'll, I'm not going to read this whole slide out loud, but there's an important piece in here that integrated services are those that provide individuals with disability opportunities to live, work, and receive services in the greater community. If you've read the Home and Community-Based Service Rule, that same language is fully reflected in that rule. And so when I say the rule is not really anything particularly new, this is language from 2011. Olmstead is from 1999. And so we're sort of well on this road, and the road is not particularly new. At the same time, there's other guidance from the Department of Justice about just straight up kind of how state and local governments provide services to people with disabilities that says very similar language. So the rule is really kind of just saying, this is what we're doing. Those who live in community settings must sort of have all of these opportunities. I did want to sort of bring up a couple of Olmstead cases to illustrate to you all how the rule has been reflected in prior litigation and prior decisions. So Lane versus Kitzhaber is a case out of Oregon, and that case was about work, about segregated workshops where people with disabilities were only working with other people with disabilities and were not integrated into the community. This may look like a day program, sheltered workshop, something along those lines. And in Lane versus Kitzhaber, the court said that Olmstead says that a person with disability has the right to work in an integrated environment. That to segregate them away from the larger community in a work environment can also violate Olmstead. Also, in Pashby versus D'Elia, which is a case that I worked on in North Carolina, I thought this one was particularly relevant for the HCBS rule because in that case, the settings that were determined to be institutional in nature were not technically institutions as you would usually consider them to be. They were assisted living facilities, and they were created a very institutional environment such that the court said, yes, this violates Olmstead because the people in these facilities, although they have a list of rights under the state statute, their experience is not integrated, and their rights are being violated by the state's change in services that would force them to go live in these settings. So this is particularly important when we're looking at how the your state's current statutes and regulations kind of set forth rights for people with disabilities. Your state statutes and regulations can say all these wonderful things about what a person's rights are, but if the person's experience in that setting does not meet the spirit and the wording of the rule, it could still be considered institutional by the courts and by anybody else investigating it. So when we're talking about this new rule, it's not about just sort of meeting the bare minimum. That doesn't get you out of potential Olmstead compliance. It really has to make sure that the experience of the individual is truly integrated and reflects their choices and how they want to live their lives. Did I lose it? I lost that one. Okay. Sorry, I got distracted there for a minute. Also, a few other cases that cite some very interesting language. Guggenberger versus Minnesota also found a lot about isolation of an individual. Steimel versus Wernert is a very important case, and it's recent, where people were on the waiver, and the cut in waiver services or change in their waiver services meant that they were not out in the community as much. And the court said that it can still be an Olmstead violation and a violation of their civil rights if they're not allowed to go out into the community to the extent that is appropriate for their needs and for their lives. And so also similarly in Murphy versus Minnesota, that is a case from actually this year, and that case said that a person with a disability on a waiver service has a right to try to access individualized supported living. And it's not okay just to be in a small group home if the least restrictive environment for that individual is more independent living. The state has to operate a program in a way that really ensures that to be happening. So that's what I'm saying about this rule, is that we're not just talking about, oh, a person has a right to live not in an institution but in a group home. It's really about what is your experience like? How are you really integrating your community? Is it about your choices? Are you in the least restrictive setting? All of that is all kind of the heart of this rule, and that's the heart of Olmstead. And so the two things are very tied together. So fighting against the rule is kind of a lost cause in some way in a legal world, because Olmstead's still back there saying, well, this is the person's civil right. So when we talk about the actual goal and scope of the rule, come on, there you go. It really is all of these things. So the preamble to the rule and the preamble in the Federal Register before the rule is set forth really sets forth and says, this is the purpose. We want to ensure that people are receiving services to the full access to the community, expand opportunities for meaningful community integration, and that's why we're doing this. Quick review of the rule itself. It's been around since 2014. Some pieces are already implemented. The part about settings and compliance with settings was originally supposed to end in 2017, and it has been extended to 2022. But states still have to have a transition plan in place by 2019. And I believe Utah already has their initial approval for their transition plan. But the whole point of this process is that there's time. CMS did not just sort of say, and CMS is the Center for Medicare and Medicaid Services, who is in charge of the rule. They didn't say, okay, well today settings have to look like this, and tomorrow they have to look like this. They have given states and providers and individuals a lot of time to achieve compliance and to really meet the obligations of the rule. And the whole thing is an ongoing process. It's trying to get better and trying to understand what you have to do differently. So we covered a lot about, oh, stop. So we've heard a lot about sort of the why, and I'm not going to go over this again. But the key thing is that we've never had a definition of community-based service before, and that's what we have now. And so it does feel a little bit like there's this new thing over top of us. But it kind of isn't. Like I've said before, we've had this obligation already. I want to make sure I have time for questions, so I was checking the clock. Okay. So I wanted to do, sorry. I wanted to do a quick review of the actual rule itself. I know that there will be a one-on-one kind of session on this that'll get a little more depth. But for those of you who are going to other sessions instead of that one, there's a quick review of what is an institutional setting. We've been talking about this already. Institutional settings are like nursing homes and state hospitals, state IDD centers. And things that are presumed to have institutional qualities are ones where you have a lot of settings on the same grounds as institution, settings that have the effect of isolating individuals. And this could include farmsteads, gated communities, that type of thing. Compare that, though, to the community-based settings, where you have people who are integrated in and have full access to the greater community. They're selected by the individual. They ensure individual rights of privacy, dignity, and respect, and they optimize autonomy. The key thing is that you have these big differences. You want to make sure that the person in a community setting has a lot of autonomy, has a lot of choice, and that's a key part of the community-based setting. And of course, anything that's provider-owned and controlled has additional requirements. And I do want to say something quickly. A lot of people assume that if a person lives in a private home, then that's clearly community-based. In actuality, the rule says that, or this guidance after the rule says that a person can be presumed that if they live in a private home, that's community, but a state still has an obligation to ensure that that person's experience meets the standards of this rule. And it could be that a person who's living in a home with a relative is not having a truly integrated experience. So this rule is not kind of just about provider-owned and controlled settings or institutions. It's where all the services are provided. It's day programs, it's the workshop type settings, and then it's all versions of living environments where people use services. And like I said, the provider-owned and controlled settings have additional standards that have to be met to ensure that a person's rights are protected. Of course, there has to be privacy in their own unit. They have to have a choice of roommate, the opportunity to decorate their own space, and the right to visitors at any time. And these are all things that, when you think about a person's life, when you're living at home, these are things that you would generally have the right to do, to decorate your own room and to have your visitors come over. And that's the same sort of additional criteria for provider-owned and controlled settings. But I turned it off. Well then, there we go. What I really wanted to sort of hit home to everybody is that the regulation is not trying to just kind of crack down and shut down providers. The regulation is trying to improve the individual's experiences in their own settings. They're just to make sure that when we're using HCBS funds, and those are waiver funds, that those funds are actually providing community-based services. When I showed the chart about sort of where Utah falls in LTSS funding, whether or not you're putting money in institutional settings or in waiver settings, if your HCBS money is really going to institutional settings, you're not making a whole lot of progress either on that chart or in your Olmstead obligations. So you want to make sure that your HCBS money for your waiver funds is really providing true community-based settings. And that's the point of the rule. It's not to shut down providers, it's to kind of bring providers to a place where they're meeting the obligations of the rule and meeting the obligations of the person's civil rights. And as I've said before, the focus is not on whether a provider is offering like 4 outings a week to a person. It's whether or not the person is experiencing the community in the way that they should. So we're not talking about like, oh, how do I meet the bare minimum? What's sort of only required of me? It's trying to twist that perspective a little bit and focus on how is this individual living and experiencing their life as they're being supported by the waiver. So I said briefly before that all of the settings are covered by the HCBS rule. If a person receives HCBS services, those settings must meet the obligations of the rule. So the state has to assess and categorize all of the settings. It's everything. No HCBS provider is excluded from the rules requirements. And like I said before, even private homes, the state has some level of an obligation to ensure that a person is having a home and community-based experience out of that private home. So ultimately, though, if you're saying, well, I'm complying with HCBS rule, the state's complying with the HCBS rule, then we're good. That's not necessarily the case. Although the HCBS rule and Olmstead are really tied together, and the HCBS rule reflects Olmstead, there is a clear statement by the Department of Justice and sort of reflected in the rule itself that the state's obligations under the Americans with Disabilities Act and Olmstead are independent from the requirements of the Medicaid program. So a state is not going to be able to say, well, we have created a compliance plan for the HCBS rule. That can be fine and good, but if the facts show that people with disabilities in that state are not experiencing life in an integrated way, saying that you've complied with the HCBS rule is only a part of the puzzle. You could still sort of be violating Olmstead. So although they're very much tied, sort of don't think that you can sort of rest on laurels and say, well, we're complying with the rule, we're good, nothing else is going to change from here. There will be sort of an ongoing look at it from the Olmstead perspective. So as we kind of put all of this together, I didn't want to be confusing there about saying HCBS rule is not compliance with Olmstead. They're just 2 different things. But states will use HCBS to meet their Olmstead obligations in terms of providing services to the people in the community as opposed to in institutional settings. And this is all part of the puzzle. And the federal government helps to pay through Medicaid for the services that will help people stay in the community. But it's all a little bit different still. Like you still have an obligation under Olmstead that does not necessarily met by just rule compliance. And you could be complying with the rule in not a full and complete way. So that is all sort of 2 different analyses a little bit. They're tied together, but they're different. And I went a little fast through that, but I did want to have a little bit of time to answer questions. Also, I have a slide in there just to sort of indicate where those charts I had came from. And I did want to point people to the website for hcbsadvocacy.org. It is a website created by the federally funded organizations for developmental disabilities, and they have put together a lot of great resources on what does the rule mean, what does it look like in different states, tracking the different states, and also additional sort of technical assistance. CMS, which is the people who oversee the rule, also have a lot of guidance on the rule. Compared to other kind of federal regulations, there's more guidance about this than I've probably ever seen on anything else. And they are really trying to make sure that everything is implemented well and that people have as many answers as they can to questions. There are still a lot of areas, of course, where people are like, well, what about this? How do I comply with this? Not everything is explained, but between presentations, questions and answers, a lot of other guidance, there's a lot of information up there. And of course, Disability Law Center, and I'm sure the state agency has additional thoughts about how the rule will be implemented and what it looks like for Utah. So with that, I did want to sort of have a little bit of time to answer questions people may have. And I may defer some questions until later this afternoon when Serena Lowe, who is your lunchtime keynote speaker, since she is from ACL and she is a federal government person who's working on this a lot, I may say she might be the better person to answer that question. But if there's any questions, I will answer them. Any questions? Oh, there. I'll wait for your microphone too. We have a microphone runner, and then that way everybody can hear your question.
Right now, because of all of the things that are going on in the southern part of the United States, in Florida and in Louisiana. Is this on? I guess it is.
I think that was.
No.
I do not see another microphone.
I'm going to stand up. I don't think this works. Because of what's going on with the hurricanes that are happening in the southern part of the United States right now, and the number of people that are involved in sheltering, does Olmstead or the HCBS have provisions for shelters?
So the question was, based on all the sort of people being displaced from hurricanes, whether or not Olmstead has provisions for shelters, or whether or not the rule has provision for shelters. So shelters are actually covered by the Americans with Disabilities Act, which is the heart of Olmstead, which is where Olmstead comes from. And so they do have to provide services to people with disabilities to ensure equal access. The HCBS rule, sorry, let me back a little bit. If a person is receiving HCBS services, they have to live in a setting that is integrated in the community. And so that would be a question about whether or not a shelter is integrated in the community. I'm sure there is a little bit of this is my own thought, that there's a little bit of leeway if somebody's kind of been displaced, because there are provisions when a person has to leave their state under a waiver and what happens in that scenario. So there are sort of backup systems for that. It's kind of an odd scenario, so I don't know if there's a clear answer, but there is one clear answer that the shelters are covered by the ADA. And so but usually it's to ensure equal access. And so they not to be discriminated against in that scenario. I don't know if that answers your question.
It answers it to the extent that I think it can be answered. I don't know that there's a clear statement on this anywhere.
Right. I saw another question.
Yeah, I had a question. What's the recourse for people who find a gap in... Is this working now? So for people who are receiving services, but they find a gap and they need help, like there's a part missing, and they don't feel like they're getting the full services they need, what is their recourse in between saying, hey, this isn't right, and filing a lawsuit? What's in the middle there?
So are you saying, I need to ask a few clarifying questions, that is it a scenario where the person maybe doesn't have enough services to get out and about, or
say they have Medicaid and they have a service that provides them a ride to their doctor's office, but they're losing mobility and they can't get from their apartment down to the curb that's provided, and they only provide curb-to-curb rides. They won't come into your home and bring you down to the vehicle. What does that person do?
So that question's a bit outside of the HCBS rule, because it's more about, I mean, there's a housing component there, because the person may need to break a lease to move to a lower level of apartment where they have accessible apartment, accessible living. They may need to find that apartment. It could be, though, that HCBS services can provide the personal care attendant to help them get from the apartment to the ride. And then it could be that, okay, the person comes in at 7 a.m., helps get the person ready, makes them a meal, and then gets them down to the car and out to the road, and then their service time ends. So there's a lot of components to that question that are not all HCBS and are a little bit of housing. Does that answer the question?
Yeah, so you can't just say, oh, the ride people need to change their policy. You've got to look at all the other...
I mean, sometimes you can say the ride people need to change their policy. You know, every service that's offered by offered by the government has to meet Title II of the ADA. That means that person has to have equal access to that service under the ADA. And so there are certain times when a service may have to change a little bit to ensure equal access for an individual. There could be longer term solutions like the ones I talked about though. Any other questions? Yes, ma'am. Wait for the microphone if you will.
So I'm wondering, as there is so much talk about restructuring the Medicaid program and giving states more flexibility, how is this rule going to fare? Is this something that is going to remain, or is this something the states will have some leeway with?
So that question is something that nobody really quite knows, but because this rule, as I mentioned before, is actually really connected to previous Olmstead litigation and what the law says people with disabilities have the right to, even if CMS backs off on certain standards, which I don't know that they really are going to do. There are other rules that are in the sites first to give states flexibility. Even if the states are given some sort of flexibility on this rule, the states are not given any flexibility on their obligations under Olmstead. So the state can back off of this rule and sort of make use of any flexibilities offered to them, but that means they may not be in compliance with Olmstead.
I love the settings rule and getting people integrated. My question that keeps coming up in my head is, where does it go with funding? Because DSPD has a limited amount of funds, the state has a limited amount of funds, Medicaid has a limited amount of funds. And the reality is if we give everyone exactly what they need to be as fully integrated, I don't think there's enough money. So where does that fall in with it?
So there are a lot of questions and issues about funding, and one of the things that I think CMS has suggested to states and advocates have certainly suggested to states is that one of the things that needs to be considered when you're looking at the state transition plan for how do you comply is how are services set up, how are those services funded, and how are individuals' budgets created, and what's the basis of those budgets. So for instance, if a state relies on a lot of group-based services, and those group-based services are not going to necessarily meet the need, individualized services are often more expensive. And so you kind of need to look at the array of services being offered and how budgets are determined. And so there is that big question, and states, in order to meet the obligations of the rule, should be adjusting those things as well. Ultimately, though, like, even if it's going to be more expensive to serve an individual in the community than what currently is working, it's still super much cheaper than serving them in an institution, right? So, so I mean, I think that's every time there's like pushback on the funding of this, the sort of response to that is, well, we can either adjust things here, or this person will go into a facility and the state will spend way more money on this individual to provide the same type of thing. So
some of them definitely, but there is some that's not the case. Like where they are in a group setting for work, but if we want everyone to be employed out in the community, one, you have to find employers who are willing to do it, and two, there's some of them who still need to be supervised, whether it's behaviors or whatever else. So that is more, and that doesn't mean if we don't do that, they're going to end up in an institution.
Well, it still could be more expensive to serve that person than what their current budget is, but it's still less than what they would receive if they were in an institution. And I understand what you're saying in terms of like they may not really be, might not be at risk, but the waiver systems are set up that this waiver is an alternative to institutional living, and they're supposed to have enough services under the waiver such that it would kind of be what they could access in an institution. And so it's still going to be, you might have to spend more, but it's still going to be less. And I know that you're like, oh, well, the person will never go in,
no,
but.
No, that's not what I'm saying. I'm sorry I keep having questions with this. But so then where do we go as far as like our funding? DSPD isn't in control of how much money they get. Do you know what I mean? So there's only so much control even DSPD has at that point. So what's going on as far as legislature-wise? Because I mean, I know this is law, but this also doesn't tell them that they have to fund a certain amount or whatnot. So what's going on that end such that there is enough funding to do this?
I mean, I think a lot of that is, in states that have been successful at this, have really done a huge campaign of education with their legislature and said that, look, this is not something that we can get out of. This is not something that we can cheap our way through because we have to have additional funding to meet the needs of these individuals. We have been kind of getting by for a long time, not meeting the obligations under Olmstead. And if you want me to cite a bunch of case law, here are all the cases that say this is our state's obligation. And we can either fund this now and avoid a whole lot of trouble, or not fund it and open ourselves up to liability. This is your choice. And that's kind of how other states have eked some more money out of their legislature by saying, this is not something we have a lot of room to wiggle. This is something we need to do, and we need to go ahead and make it happen so that we're not leaving ourselves open to risk. Yeah. There's a question in the back.
And I apologize if you've covered this, but I was wondering what about settings rules that are currently in place but wouldn't be compliant? Are they going to be grandfathered in?
There is no grandfathering of settings. All settings must be placed under review by the state. The state has an obligation to review all of their settings. And the states are supposed to sort of put them into categories about never could be compliant with changes, are already compliant, that type of categorization. If a setting could never be compliant, even without changes, it can't continue to be funded under this rule. If a setting could make changes, say for instance it has a lot of institutional qualities, but it overcomes those institutional qualities with how a person's experience is in that setting. So for instance, let me go back a little bit and find the right slide. Yeah, I don't have, sorry, I thought I had it in here. If a setting is presumed institutional, so say for instance it's on the grounds of it's on the grounds with another institutional setting, that's considered presumed institutional. And the setting says, well, we are on the grounds of a nursing facility, but we're on the other end of the 100-acre lot or whatever, and we don't have any interaction with that setting, and our individuals who live here or who work here are not at all kind of impacted by that setting. That setting could then tell the state, look, we think we qualify. Here's the things that overcome these presumptions. Then the state has the option to send that setting through the heightened scrutiny process, where CMS will then approve or disapprove that setting to be continued to be funded based on the evidence the state provides. But there's no current grandfathering of settings, and if a setting is considered to be institutional, it cannot save itself unless it is only presumed to be institutional and can overcome those things. Any additional questions on that? Any other questions? Over here.
Thanks. I want to piggyback on the supported employment aspect of what we're talking about a little bit. In speaking with my clients and my family, my job is to protect their opportunities, just like all the rest what we're talking about here. But if I have a client or a family who can speak up and say, I like the setting that I'm in, I choose this setting that I'm in, how does that affect the rule?
Choice does not overcome, a person choosing a non-integrated setting does not overcome the obligation of the rule. So if a person wants to stay in a segregated setting, HCBS can't fund that segregated setting. There has to be, and there's ways where models are changing how they do business in order to ensure that a person has integrated opportunities within that model. So say, for instance, some states are moving completely away from any type of segregated day program. Other states are using a model where they're changing the nature of those programs so that it's kind of more like a hub from which a person has more integrated experiences. So they go to the day program, and then from there they go out and have community integrated experiences. I think the hope of the rule and the push of the rule is that a person would just be able to go to their community experience. And that's where a lot of states are moving towards. But some states are using the more kind of model about going to one place and then going from there and going out to have their experiences. But the point of that is still that you can't just spend all day in a day program doing a task where you're never going out into the community. But choice has been held by multiple times. It's a provision in the Olmstead case, and some parents have tried to intervene in cases about Olmstead, and they've said, well, we choose to live in an institution. And the Supreme Court, the various courts have looked at it and said, okay, but choice still does not overcome the state's obligation to provide integrated settings. And so if the state still has to meet their obligations, and your choice doesn't really change a lot about that. And that's not to say, and I don't mean for anybody to take this the wrong way, that what a person wants to do is irrelevant. That's not true. Under Olmstead, a person has to want to live in the community. And so there's still a really big piece of that. But if you want to live in the community, then you're using HCBS. And if you don't want to be integrated in the community, then you're using some other funding source. And that's kind of the line that's drawn, because HCBS is supposed to be used just for community-based living, and other funding sources are used for segregated settings. And then it's up to the state as to how they balance that kind of funding, as to whether or not they feel like they're meeting their Olmstead obligations, so that there's enough community-based services for people who want to live in the community and work in the community. Are there other questions? Yes? No? Oh, one more.
So with the job that I'm employed through, I work in a lot of the frontier areas of Utah, and I have found that the families that live in those frontier areas, they do not have community support base at all or access to anything like that. And I've found that a lot of families have been told that they need to move to somewhere bigger. So although they're in their community, want to live in their community is not helping them in that sense. How do I advocate that? Because I've gone to the Department of Human Services, I've talked with DSPD, I advocate for them, and they've told me, you need to go talk to your legislator. So.
Well, so we've had the discussion about what DSPD needs to go talk to their legislature about, but it is the state's obligation to provide Medicaid services throughout the state and ensure access to those services under 1396A30A of the U.S. Code of Medicaid Act. So that is the state's obligation. And you're doing all of the right things by advocating and saying there's a lack of services in this area, and the state should sort of be tracking that and doing things to attract more providers to that area. There are a few cases about whether or not a state has to have the same services all across the state. Like there's a case about ICFs, and parents wanted the ICFs in Chicago, and the state said, well, but we have ICFs elsewhere, and the state won in that case. But the home and community-based rule really is about like making sure that you have services in your community and in the community kind of in which you live. And so that kind of is a different question than in that particular like ICF case. So you're doing all the right things. Your expectation that the state should have services in that area is not unreasonable. It's just a matter of trying to work with the state to figure out how can you either attract providers to that area, or what can they do to overcome that kind of problem. Because it may be about thinking creatively, or trying to work with other state entities to create jobs, because those services create jobs. And that's one way to kind of sell that. But there's a lot of ways to think about it other than just trying to push the state, which you should definitely do. But there are other ways to kind of solve the problem. So your expectation is not unreasonable.
I have more of a comment than I do a question, and that has something to do with the working and with the frontier areas out here. I work with multiple state programs, and I work with the United States military nationally and internationally. And one of the things that I'm seeing in a lot of the other states that I get to work with with this rule, one of the things that we are not doing here in Utah, but successful states are, is that the disability services, the families, and the individuals have all banded together as a coordinated group. Now, we have small groups here in Utah, and they're doing okay with what they're doing, but we're so scattered that we've got what one of the legislators I spoke with last week called it slop. There's not enough concentrated effort in one direction. We've got people going this way, we've got people going that way. One of the programs that works really well and that I recommend that people look at for perhaps some modeling that we could use here in Utah is the Take Your Legislature to Work program in the state of Wisconsin. It's done by the BDD in the state of Wisconsin, and I'm sorry I can't tell you what the acronyms are. Being military, I speak more acronym than I do long phrases.
I do too.
But it is, you can look them up. It's Take Your Legislature or Legislator to Work program, and there's a whole bunch of connected and interconnected HCBS information that goes right along with that. So it's not just one item, it's the whole thing. And we need to start looking at that as a possibility here in the state.
I think it is a really important piece to be telling, since the legislature is who's determining the funding that's available to the program, which is in some ways constraining things or creating some barriers, it is really important for individuals and sort of advocacy organizations and provider organizations to sort of band together and say, this is the message we're sending. This is how a person's experience is supposed to look like, and this is what it doesn't look like. And stories and kind of examples are the things that are most compelling to legislators about this is what a person's experience is currently like, and this is what it's supposed to be like, and this is how we need changes, and this is why we need additional funding and other types of things. So it is really helpful to do stories and try to create a cohesive message so the state's not the only one saying, like, please give us more, because they hear that every year, I'm sure.
I just have a follow-up to that comment. The Utah Developmental Disabilities Council, they run that program every fall. So if anybody is interested in participating, get in touch with the DD Council, call Claire, she'll hook you up with how to do that.
All right. I think that is my time. So I want to make sure everybody has time to get up and move around and go on to their next session. So I thank you all very much for being an attentive crowd and listening to my Olmstead ramblings. So thank you.